Good morning, Doctor. I'm Yee Shin, and today I'll be presenting on the topic of why trustees are fiduciary and the modern relevance of trust law. Trust law forms one of the most distinctive standards of equity and plays a vital role in the administrations of property for the benefits of the other. At its core, it lies relationship between trustee and beneficiary, which is founded on fiduciary responsibility. Trustees are entrusted with significant power and discretion, but that power is constrained by equitable obligations to act exclusively in the interest of the beneficiary. In these presentations, I'll first explore the legal reasoning behind why trustees are considered fiduciaries and then assess the modern relevance of trust law, particularly by highlighting its applications in estate planning, financial regulations, and global assets management. Trusteeship involves a legal relations in which one party, the trustee, holds and manages property for the benefit of another, the beneficiary. As the House of Law laid down in Re Code Will Trust, and equitable obligations binding a person, the trustee, to deal with property which he has control for the benefit of person, the beneficiaries, or for charitable purpose. This definition captures the key features of fiduciary relations. Separations between control and benefit. Section 2 of the Trustee Act 1949 defines a trustee as including a trustee, corporations, and every other person holding property in trust. This broad statutory definition extends fiduciary responsibility beyond individuals to institutions acting in a trustee capacity. Whether the trust is expressed, implied, or constructive, the trustee carries with them fiduciary obligations, namely the duty to act honest, loyalty, and prudently in managing the trust property. The idea of fiduciary duty arises when one person is entrusted with discretionary power over another interest. Paul Miller argues that fiduciary duty exists in order to protect the principle from abuse of power by fiduciary. Similarly, another scholar, Matthew Conaghan, explains that fiduciary duties ensures that other legal obligations such as prudence or care are carried out without being compromised by self-interest. The judicial basis for judiciary duty is further supported by Lord Justice Millett in Bistro and West Building Society and Murphy, who emphasized that fiduciary obligations are primarily about loyalty, not skills or diligence. He stated that a fiduciary relationship arises when one party undertakes to act for another, in circumstances giving rise to relationship of trust and confidence. Thus, trustees are fiduciary because they exercise power in relationships defined by dependency and confidence. One of the clearest reasons why trustees are considered fiduciary lies in structural divisions of ownership which underpins trust law. A trustee holds the legal title and therefore controls the property, while the beneficiary holds only equitable interest and have no direct control. This division creates a power imbalance which equity step in to address by imposing strict fiduciary duties to protect the vulnerable party. In West Church, Lamberg, and Islington LBC, Lord Brown Wilkinson emphasized that trustees are bound in conscience to exercise their legal powers solely for the benefit of others and not for themselves. Legal scholar John Langban explains that these structural separations between legal and equitable ownership invites fiduciary obligations precisely because of the asymmetry of control and risk. Trustee acts unilaterally, whereas beneficiary bear the consequence. This principle is borne out in Broadman and Phipps, where the court required trustee to account for unauthorized profits derived from information gained in fiduciary capacity. A similar result was reached in Regal Hastings Ltd and Golvier, where company directors were held liable for profits earned from their fiduciary positions, underscoring the strictness of fiduciary standards. These cases demonstrate that where a person holds legal control over property belonging in equity to someone else, they must be subject to duties of the highest loyalty, integrity, and accountability. Trustees are deemed fiduciary also because they hold wide discretionary powers in administrating trust affairs. These powers include the ability to make investment decisions, to distribute property, or to interpret the trust deed. Because such discretions could easily be misused or led to neglect, fiduciary law imposes strict duties to ensure the decisions are made honestly and for proper purpose. In Coven and Scargill, the court held that trustee must act in the best financial interest of beneficiary, rejecting decisions driven by personal or political beliefs. Correspondingly, the Trustee Act 1949 reinforces this fiduciary framework. Section 4 to 6 require that trustee act responsibly honest, and in the best interest of the beneficiary, while Section 9 allows investment only in authorized financial instruments, thus regulating the exercise of discretionary investment powers. These statutory provisions align seamlessly with the fiduciary principles of care and loyalty, requiring trustees to prioritize beneficiary welfare above their own. A further core reason why trustees are fiduciary lies in the duty to avoid conflicts and interest and personal gain. The rule originates in Keith and Sandworth, where a trustee who honestly renewed a lease in his own name was nonetheless ordered to transfer the profit to the trust. Even though the trust was not harmed, the court imposed liability because of the strict nature of fiduciary obligations. More recently, in Morat and Al-Sarraj, a fiduciary was required to account for profits made without full disclosure despite the absence of financial loss to the trust. These cases illustrate that fiduciary law is not concerned solely with outcomes, but with the integrity of the relationships. Trustee must act with undivided loyalty and full transparency, not merely avoid actual harm to the trust. Another reason trustees are classified as fiduciary is the nature of the remedies available when they breach their obligations. Equity affords proprietary remedies which go beyond mere compensations for loss. For example, in Attorney General for Hong Kong and Raid, the Privy Council held that bribes taken in breach of a fiduciary duty were held on constructive trust for the principal. Similarly, in FHR European Ventures LLP and Cedar Capital Partners LLC, the court confirmed that unauthorized fiduciary profits are subject to tracing and proprietary recovery. In Malaysian context, although landmark decisions remain fewer, courts have indicated that constructive trust may be applied to remedy misconduct. Legal scholar like Hang Butang in his journal article argues that Malaysian courts should develop clearer and more principled doctrine in this area. These equitable remedies highlight the continuing importance of trust law and maintaining accountability and fairness. Finally, trustees are fiduciaries because their role is fundamentally protective. They manage assets on behalf of beneficiaries who are by definition in a weaker positions. In Hospital Products Ltd and United States Surgical Corporations, Chief Justice Manson described fiduciary relationships as those involving one party's ascendancies over and the another's dependency. Further, in Armitage and Nurse, Lord Justice Millett acknowledged that while many trustee duties may be excluded by the trust instrument, there remains an irreducible core of fiduciary obligations, namely honest and good faith. These judgments affirm that trustee and beneficiary relationships is inherently fiduciary because it rests on confidence, dependency, and the need for conscience-based regulations of power. Moving on to the discussions of modern relevance of trust law remains highly relevant today because of its flexibility and broad applications. It is widely used not only for managing family wealth, but also plays a vital role in modern financial institutions and global contexts. One of the most practical applications of trust law today is in estate planning and assets protections. Trusts enable individuals to separate legal ownership held by trustee from beneficial enjoyment enjoyed by beneficiary, allowing for efficient intergenerational wealth transfer, privacies, and protections from probate or family disputes. In Malaysia, this is especially pertinent for Muslim settlers where hybrid structures such as the Hibah Trust have emerged. Scholar like Hang Butang in his journal article explains how Hibah Trust blend English trust framework with the Islamic concept of gift, which is Hibah, enabling settlers to retain lifetime control and ensure distributions in line with Sharia corporate trustees such as Maybank Trustee Berhad offer both Muslims and non-Muslim estate planning solutions, including private trust and Hibah Trust. In a typical arrangement, Maybank acts as trustee, holding and managing the settlers' assets according to the trust date, ensuring distributions occur either pursuant to the settlers' personal wish or Sharia-compliant mechanisms. Moreover, trust law continues to provide flexible judicial remedies through the impositions of constructive trust. Court may declare that someone holding legal title must account for another where unjust enrichment or misuse of property occurs, even if no formal trust exists. Although Malaysian jurisprudence in this field remains comparatively undeveloped, this underlying concept illustrates how trust law remains adaptable. As scholars suggest, courts in Malaysia should embed clearer principles for constructive trust. The availability of such remedies show how trust law continues to provide tools for justice in modern commercials and private disputes. In addition, trusts remain relevant in modern trust law because its structure underpins much of the modern financials and investment infrastructures. Unit trust funds, pension schemes, and real estate investment trust REITs rely only trustees to hold and manage assets for beneficiary. In Malaysia, this is illustrated by the Employees Provident Fund, which is EPF, the National Retirement Savings Scheme, which operates as a statutory trust. The EPF board holds and manages the funds of contributors and owes fiduciary duties to act prudently, diversify investments, and secure long-term benefits for its member. Similarly, in Sunway REIT, a major Malaysian REIT, a trustee companies hold legal title to property assets and ensures that income is distributed to unit holders according to the trust deed. The Security Commission's Malaysia's guidelines on unit trust funds further require trustees to act independently, maintain proper records, and oversee compliance with regulations, reflecting key fiduciary principles of loyalty, care, and accountability. Moreover, scholars like Stephen explains that trustees in the bond market serve as gatekeepers monitoring compliance, initiating enforcement when necessary, and thereby protecting the rights of investors in complex financial arrangement. This commercial trust use demonstrates how trust law remains relevant and performs vital economic functions. Also, in Malaysia, the continued relevance of trust law is reinforced by statutory frameworks such as the Trustee Act 1949, which remains the core legal instruments for governing trustee powers, duties, and liabilities. Section 4 to 6 of the Act outline general fiduciary obligations requiring trustee to act honestly, loyally, and prudently. Section 9 regulates investment discretion. Section 23 obligates trustee to keep account. Section 24 limits unauthorized delegation. These statutory provisions effectively translate the equitable principles of fiduciary loyalty and carry into accessible legal standards. The ongoing use and interpretations of the Act demonstrate trust law enduring place in Malaysian legal infrastructure. Trust law likewise remains pertinent in global economy where individuals and companies often own assets in multiple jurisdictions. Malaysia Labuan International Business and Financial Center allows the establishment of offshore trusts and Islamic trusts designed for assets protections, tax planning, and international estates structuring. This global dimensions of trust law is explained by Lionel Smith, who argues that the universal nature of fiduciary obligations make trust law adaptable across different legal systems. Whether legal title is held in one country and the beneficiary lives elsewhere, the core concept remains. A trustee acts for another under a relationship of confidence and control. Accordingly, trust law remains an indispensable tool for global wealth management, cross-border estate planning, and international financial structuring. In conclusion, trustees are considered fiduciary because of the significant power they hold over property intended for someone else's benefit. This power, combined with the vulnerability of the beneficiary, give rise to strict equitable duties of honest, loyalty, and prudence. These duties are not simply contractual obligations but reflect the structural features of the trustee-beneficiary relationships and are enforceable by equitable remedies. Trust law remains highly relevant today because it offers versatile and robust frameworks for personal wealth management, institutional investment, financial regulations, and global assets flow. Trust law operates not only through common law principles but also via statutory regulations and Islamic wealth management innovations, demonstrating its continued vitality and adaptability in a globalized legal and economic environment. That's all for my presentation. Thank you. The following slides will be the bibliography.